This episode is brought to you by Travis Bull Johnson, who is running to be the next representative for the 7th District of Minnesota. If you want to find out more, go to bulljohnsonforcongress.us.
And now, Matt Wright and Spike Cohen.
Good morning, good afternoon, or good evening, and welcome to the Vanguard. For Spike, former VP Al Goy Cohen, I am Matt Wright, and together we are traversing the muddied waters of freedom. First and foremost, allow me to thank Benjamin Daniel Morris Chestnut, the 13th, for the kava I am drinking on this week's episodes.
And allow me to thank Costco Daniels Kirkland Signature, the 37th, for this purified water that I got from Costco, Bulavanaka. Little known fact, Costco is named after Costco Morgan Kirkland Signature, the 32nd. They just shortened it to Costco. So,
Fair.
Greek name. This is a Muddy Waters Media production. Check us out on all social media platforms, on all podcasting platforms, or wherever you are listening or watching this right now, and wherever that is, like, follow, subscribe, hit the bell, and all that stuff. And of course, if you have not already done so, head on over to anchor.fm/muddywaters/subscribe to become a member of the Muddied Mud People Militia. Become a member, subscribe to Muddy Waters, and if you do that, then you get access to exclusive weekly Muddy Waters Media members-only content. You also get an ad-free experience on Anchor and Spotify, and you get a discount at our Muddy Waters Media store, which is at muddywatersmedia.com. You get a very wonderful discount there as well, and all that for only $10 a month. So sign up right now.
Right now. So as we know, the Supreme Court decided not to release any opinions for the first month for some reason. And then in the last week, they are just pushing these things out as fast as they can. One of the opinions that came out last week had to do with gun control. So let's go through a brief history before we get into that case. In 2008, the District of Columbia versus Heller, a very famous gun control case, that was decided on by the Supreme Court.
Decision.
Yeah, the Heller decision. The Supreme Court held that the Second Amendment secures the right to possess a handgun inside the home for self-defense purposes. Obviously.
Yes.
This was after D.C., of course, tried to ban handguns throughout the entire city. The Supreme Court spanked them back into submission and said, no, you can't do that. In McDonald versus Chicago in 2010, the right was applied against state and local governments. So not only could it
Meaning that it was not... Go ahead.
That it wasn't a city making this, but like also larger governments couldn't make this same rule.
So there was a belief among some that the Second Amendment only applied to the federal government. Even though it says the right of the people to keep and bear arms shall not be infringed, it didn't say shall not be infringed by the federal government. And in the amendment right before it, it says Congress shall make no law restricting, and then it goes on to the right of the freedom of speech and the press and all of that stuff.
Right.
And everyone recognizes that doesn't just mean Congress, it means everyone. But for this one, which didn't even specify Congress, to going, no, that meant that the states and the locals could definitely do that. And the courts correctly said, no, that right was throughout, and no one, including state and local governments, can infringe on that.
Correct. So this last week, in New York State Rifle and Pistol Association versus Bruin, is it Bruin or Braun? I've only read it, so...
I think it's Bruin.
Okay. Is it Bruin?
I think it's Bruin.
All right.
Yeah, I think...
I've only read it, and I was like, as I was reading it, I don't know if I've ever said this word out loud. The right was recognized to extend outside the home, because obviously the right of the people to keep and bear arms shall not be infringed. It's kind of there in
Did not mean just in your house.
Right. In a landmark victory for gun rights activists, the U.S. Supreme Court ruled 6-3 that the Second and 14th Amendments protect an individual's right to carry a handgun for self-defense outside the home. And I know what a lot of you are thinking, and we're going to kind of discuss a lot of what they didn't say, but they did say in a little bit, so bear with us. For over 100 years, New York had a law requiring anyone seeking a license to carry a concealed handgun in public to first satisfy a local official that he has proper cause. A generalized wish to carry a concealed weapon for defense purposes was not sufficient to meet proper cause standard. So just saying, hey, just in case I happen to be at a supermarket in Buffalo and somebody decides to bring a gun in to start shooting the place up, I would like a gun to stop that person.
Hypothetically
Was not considered sufficient to meet the proper cause standard.
Yeah. Now that guy who illegally had a firearm and used it to kill people or try to kill people, they didn't factor that in.
They did not, no.
But you can't have a gun.
No. In 43 states, observed the majority opinion by Justice Clarence Thomas, who truly has been dunking all over the people who hate him this term. Good God, just like Tracy McGradying right over everybody. Good God. The government issues licenses to carry based on objective criteria, but in 6 states, including New York, the government further conditions issuance of a license to carry on a citizen's showing of some additional special need. Because the state of New York issues public carry licenses only when an applicant demonstrates a special need for self-defense, we conclude that the state's licensing regime violates the Constitution.
Yeah. And not just the Second Amendment.
No, the Second and the 14th.
Yep.
Second and the 14th.
Yep.
Question of whether the discretion that New York placed in the hands of local licensing officials was consistent with how constitutional rights are typically treated in the American system, Thomas said, "We know of no other constitutional rights that an individual may exercise only after demonstrating to government officers some special need, unless you're a felon. That is not how the First Amendment works when it comes to unpopular speech or the free exercise of religion. It is not how the Sixth Amendment works when it comes to defendant's rights to confront the witnesses against him. And it is not how the Second Amendment works when it comes to public carry for self-defense." I don't know if I have it in here, but in his majority opinion, he said, not a lot of people are holstering a pistol in their bedroom or at the dinner table. And I thought, Justice Thomas, you need to meet more libertarians.
Yeah.
Because I bet
there's some that wear them in the shower.
You're right.
But for normal people, yes,
right.
That's not when they are. And it violates the 14th Amendment. Obviously, it violates the Second Amendment because the right of the people to keep and bear arms shall not be infringed. It violates the 14th Amendment in equal protection because it straight up says, yeah, we're going to discriminate against people based on our arbitrary case-by-case decision whether or not someone has, we're going to let them exercise their constitutional rights. Not you can't, but it depends. You probably can't, but you might. We might let you, but we really got to hear your story first.
Right.
That is a textbook example of violating the 14th Amendment. It would be like saying, well, not everyone can vote. Let's see if you really need to vote. I'd like to get to meet you first, talk with you a little bit. Then we'll decide if you really have a special need to be able to vote. Or, that's a perfect example of violating the 14th Amendment.
Right. Or, we want to have a rally. We want to have a political rally and talk about, ending some government program. Well, let's sit down and talk first because I'd like to meet you and talk to you before I let you exercise your free speech.
Yeah, exactly.
Each year, a coalition of public defense lawyer organizations, including the Black Attorneys of Legal Aid, the Bronx Defenders, and Brooklyn Defender Services, told the court in an amicus brief, each year we represent hundreds of indigent people whom New York criminally charges for exercising their right to keep and bear arms. For our clients, New York's licensing requirements renders the Second Amendment a legal fiction, which it has.
Yeah.
Which it absolutely has. They're telling you, yes, we can't stop you from owning a gun, but you can't take it anymore. And we're doing everything we can to make sure you can't really own one. In addition to New York, California, Hawaii, Maryland, Massachusetts, New Jersey, Rhode Island, and Delaware all require residents applying for concealed carry permits to demonstrate a justifiable need to carry a concealed weapon. Gavin Newsom.
Well, they used to. Now they can't. Now every state has to be shall issue. Or not issue. Or they could just not require a permit. That's the other option.
So do you think that I'm going to have to pull this up on my phone, that the California Attorney General accidentally published full list of every concealed carry member in the state to include names, home addresses, phone numbers, sex, and race of every member on the state government website in retaliation to this decision?
Yes.
Right?
Absolutely. Yep.
There is no question in my mind. For anybody who doesn't know what we're talking about, I'll just say it again. The California Attorney General accidentally publishes full list of every concealed carry member in the state to include names, home addresses, phone numbers, sex, and race of every member on the state government website. So anybody can go out there and see that, Bob Michaels from Redondo Beach has a concealed carry, and whenever you see him, he might have a gun. Anybody can do this, which could lead to the triggering, unintended, of California's massive red flag laws.
Yep. That's exactly what that was for. That was a list for swatting.
Yeah.
And thanks to the Republican turncoats who worked with Democrats to pass the newest abomination of gun control laws, that's exactly what's going to happen. Although we're already hearing of other groups that are already gearing up. There are some far-right groups who have said, the data actually shows that people who tend to have progressive political beliefs are more likely to seek medical care for mental health problems, which it could very well be just because they're more likely to seek medical care in general for that kind of stuff. It's not as stigmatized, maybe, or they're just more mentally ill, either way. Or some combination of those things. But regardless, they're going to just start naming every liberal they know and calling for them to get swatted if these red flag laws pass. This thing's going to get DDoS'd so hard. Everyone's going to be spamming it to set up people for swatting. It's going to be an absolute nightmare. But yes, I think the California Attorney General did it as revenge, and also to try to prime the pump for red flag law enforcement, which is, by the way, why hopefully this Supreme Court strikes down red flag laws as an infringement. I also think that they will end up striking down the permit requirement, because if you read the actual wording of this decision, they're very clear.
Yep.
The government telling you whether or not you're allowed to have your right to keep and bear arms is in and of itself an infringement of the Second Amendment. It may not be an infringement of the 14th Amendment, although you could argue it is, because it doesn't allow felons and people who seek, medical cannabis or things like that to have it. But even if it's not a violation of the 14th Amendment, it's a violation of the Second Amendment. So this was a very powerful decision that could be used successfully to challenge anything that falls short of constitutional carry, open or concealed, without a permit, without permission, none of the government's business, no registry, no nothing.
And a lot of people are like, I don't think that this went far enough. Why didn't he just get rid of all licensing across the board? Or why didn't they? I don't want to say he, like Thomas did it on his own. Yeah. But why didn't they do this? And it's the reasoning behind it is because they were there to decide on one case. And the thing that was brought up is, are these licensing requirements too strict? So what Thomas did, when he's good, he's really good. What he did was he was like, yes, these are too strict. Nobody has any right to require you to fill out a license to, I don't remember the wording of it exactly, but basically he said,
Right.
no government can ask you for a license to carry a gun. Shall not be infringed means no licensing.
Yeah.
That means that it is in there. It is precedent
Yep.
for at least 50 years. And then we can... And then you have it in precedent where he says, okay, well, he said that we don't need licensing anymore. So I'm willing to bet that when the fall session rolls around, there is going to be a case where they are talking about whether or not you need a license to conceal carry or to carry a gun in public nationwide.
Yep.
I would take that bet today.
And it'll definitely be used to challenge them, and I believe, and I think you probably agree with me, that it will be successful. I think that we are headed towards permitless carry, and that at that point, if we have permitless carry, then I think the next step is looking at red flag laws as a violation of both due process, unreasonable search and seizure, or limit or bans on unreasonable search and seizure, and the Second Amendment. I think that based on that decision, not just the decision that they made, but the way it was written, I think we have potentially a very, very pro-Second Amendment court, which, if utilized correctly, can be a pro-criminal justice reform court.
Yes.
Because ultimately, you can't enforce infringements on the Second Amendment without having a reckless, unaccountable criminal justice system. So I'm actually very, very hopeful about this.
Yeah, I'm very hopeful about it. Gavin Newsom, however, not so hopeful. He called He called this ruling a dark day in America. Oddly enough, not the only time he said that last week. I am willing to bet. I would bet good money. I would bet good money that somewhere out there is a picture of Gavin Newsom in blackface.
Oh gosh, I would bet good money. That guy has, I was a schmuck frat bro who did every insensitive thing I possibly could in law school, all over him. That guy, 100%, he blackfaced it.
At some point.
All we need to find is the Polaroid of it. At some point, that guy blackfaced. We're going to find it. And that'll be a truly dark day for him. And I bet he can't even moonwalk. So unlike
potential 2024 presidential candidate Youngkin.
That's funny.
Yeah, he's talking about running, and
well, no, not Youngkin. Youngkin's the Republican that replaced.
Oh, is Youngkin? Oh, okay, Youngkin is the one that replaced. What was his name?
Yeah.
North. Okay, Youngkin is the guy.
Northam. Ralph Northam.
Yes.
Glenn Youngkin's the guy that's in there now.
Yes, yeah. Ralph Northam. Okay, yes. So Glenn Youngkin's the one talking about running. I think that would be
That's funny.
I think that would be a terrible move for him, but
be a terrible, terrible pick.
But Gavin Newsom, who we know did blackface, we just don't know where that picture is.
Yes,
he said
he's definitely done that.
This is a dangerous decision from a court hell-bent on pushing a radical ideological agenda, coming from Gavin Newsom, and infringing on the rights of states to protect our citizens from being gunned down in our streets, schools, and churches. Shameful.
Well, that's a take. And then, of course, on the other side of the coin, Biden signed into law the gun control bill that we spoke about after an agreement was made 2 weeks ago. Biggest news that came from that bill is the closing of the so-called boyfriend loophole, which is a really extremely sexist-ass way of saying that basically saying females can't be abusers. Yeah. That bill would ban anyone convicted of misdemeanor domestic violence who has a current or recent former dating relationship with the victim from owning a gun. So I'm going to say that again. This would ban anyone who's been convicted of even a misdemeanor domestic violence. Which does not necessarily have to include actually like beating someone.
Right. So, from my understanding, and I could be wrong on this. I don't want to say this like it's gospel. From my understanding, is if you have a domestic situation with your wife, more than likely it's going to come out as a felony. If you have one with your girlfriend, a lot of times it just comes out as a misdemeanor. So that's why they threw this in there.
Oh, okay.
But you're
Unless
not.
you're a cop,
Well, 40%.
40%. Self-reports. 40% admits to it. The other 60% says, she fell.
Wasn't it 40% of their wives admitted to it?
No, 40% of them.
Oh, I thought it was
the
40% of their
police admitted to
wives
it.
admitted to it.
Nope. 40% of the people that were being asked, have you, basically beaten your wife or kids, said yeah. On a sheet of paper.
That's insane.
Certainly none of that other 60% said no, even though they did.
Right.
Certainly. Because if there's one thing I know about wife beaters, it's that they're always honest.
And
They're not hypocrites at all.
And they would definitely just fill out a government form saying, yeah, I did that.
Yeah, I did that. They would definitely fill out a survey saying, yes, I beat my wife. The thing is about a lot of these wife beaters and rapists and other types of abusers, it's the hypocrisy. It's the lying.
It's the lying.
It's the lying. That's the bad part. Now, some of you might think, no, it's actually the wife beating is the bad part. Well, agree to disagree.
Agree to disagree.
No, I think that basically this says, if you've ever been in a domestic dispute, which there's never any kind of false claims there, right?
Never.
But if you've ever been in a domestic dispute and are not a police officer, you now aren't allowed to protect yourself.
Right. And
Yeah.
the wording is also like massively vague in a lot of other ways.
Of course.
And, how long is a recent former dating relationship? Like, does that mean you broke up recently, like within the last, year? 2 years? 3 years? Like, how long ago was a recent dating relationship? And what is a recent former dating relationship? Like, hook up with a girl twice, and then you're like, okay. Or you hook up with a guy twice. It works both ways. I say girl just because that's my history.
Because they said it. They said boyfriend loophole.
Right. So you hook up with a girl twice, and then you're like, okay, no, she's not who I want to date because of a myriad of reasons. So you just kind of back out, and then she's like, okay, well, we were in a relationship. Now I'm going to what I'm going to do is I'm going to say that you hit me and I know you own guns. So I'm going to get you red flagged, get you charged with this domestic, and then you're going to lose the ability to have any firearms for the next 5 years.
Yep.
Just because you stopped talking to me. And again, this works either way. Like either sex can be that shitty.
Oh, it could be a guy doing it.
Yeah.
It could be a jilted, a jilted guy that you went out on a date with or said no to, because that's the other thing.
Right.
It's not hard to say, yeah, we dated. Well, no, you didn't date. You talked a few times on social media, got together, she wasn't into you, and so now you're stalking her, and then you decide to swat her, and that's what red flag laws are. They're swatting.
Yeah, it's swatting.
It's swatting with extra steps. With the veneer of a court process that really isn't a process.
Right.
There is at no point in this chain is there any negative repercussions if this is misused, right? If the person doing the snitching is wrong or lied, if the police were too quick to believe them, if the judge was too quick to sign off on the warrant with no disputing proof, to try to give them the authority to basically no-knock raid your house. If all that turns out that none of that was needed or that they end up killing someone or whatever, there's no negative consequence except for the victim of all of this.
Right.
It's a terrible, terrible thing.
No, this is awful.
The Senate said that when they wrote this, that they wanted the states to define it, but that just leads to more headaches in the upper courts and divisiveness across the board. It's going to be poorly, arbitrarily, and capriciously enforced and defined in the first place.
So yeah, like in California, it might be, you hooked up with this person twice, that counts. That absolutely counts. Where in somewhere else, it's you were together for 2 years, you were living together for a year, and that's what counts. And that's going to create so many more headaches, on top of the fact that they're funding red flag laws for states now.
Yeah. My hope, and I hate this. I hate that this is the case. As long as statist authoritarians are in charge, my hope here is that it's the Supreme Court. I mean, I hate that I'm even saying this, but that it's the Supreme Court who has to step in and say, listen, this violates the Second Amendment. You can't do this stuff. You can't do it. I hope that's what it takes. Or I hope it's not what it takes, but I hope if that is what it takes, that it happens.
That it happens.
Heller was a good decision. Chicago versus McDonald was a good decision, and Bruin was an incredible decision. Bruin is probably my favorite Second Amendment decision to come from the Supreme Court, and it's interesting because in the almost 150 years or 160 some odd years to the day of Dred Scott, where the courts, that same Supreme Court said, well, we can't allow black people to be considered citizens or people, because then they'd be able to own guns. And 160 some odd years to the day, Clarence Thomas, the descendant of slaves, said, "You're damn right it does," and drove that home. Yeah. I like it.
No, that was a huge victory for the Second Amendment. That was a huge victory for anybody out there that that owns guns, that wants to own guns, that wants to be able to carry their guns, wants to have self-protection. Huge victory all the way around. The only question is, will Congress, both the Democrats and the Republicans in Congress, screw it up?
Yes. So, but can the Supreme Court unscrew them up? You're never going to believe what happens. Folks, thanks again for tuning into this episode. And later this weekend, tomorrow. Be sure to tune in. Tomorrow, be sure to tune. That's right, because we're ahead of the thing. Be sure to tune in this tomorrow for the next subscriber-only episode. We have one every week. The next subscriber-only episode of the Muddy Waters of Freedom. And I know what you're thinking. Well, how the hell do I get to watch a subscriber-only episode? Well, if you go to anchor.fm/muddywaters/subscribe, you can sign up by becoming a subscriber today. For only $10 a month, you get exclusive access to our weekly members-only episodes. And you also get a ad-free experience on Anchor and Spotify. And you get a discount at the Muddy Waters Media store, which is at muddywatersmedia.com. All of that for only $10 a month. Get your bid in. Well, it's not, you don't really bid, you just give us $10. Get your $10 in, and let's start enjoying the truly premier Muddy Waters experience together today. We will see you tomorrow, and where we're going,
we don't need roads.